All right, everyone, welcome back for another episode of Uncontested. My name is Rob Johnson, and joining me is the man behind Lohman Law, Sean Lohman. What's happening, buddy?
Hey, Rob, how are you?
Doing well.
Good.
Doing well. So, Sean, on today's docket, so to speak, we are going to talk about updating someone's estate plan, like when to do it, how to do it. It's one of those things where I don't necessarily think it should be a set and forget type of strategy. In the last episode, we talked about how COVID changed a lot of people's perspectives on how to handle things like living wills and how to navigate those waters. So I think if COVID taught us anything, it's probably that we ought not to just, sign some paperwork, put it in a drawer and forget about it for 40 years. Is that right?
Absolutely. And, there's so many stories that I have about reviewing people's estate plans and estate plans that are out of date. One of the best, though, well, there's a couple good ones, but one of the best is a lady who called me not long ago. It was been in the last couple months. And she said, she was older, I could tell over the phone, and she said, I have an estate plan. I don't think I need one done. But I've got one in place. And I said, great. I'll review it for free. We'll go over it. And if everything looks good, then you don't owe me anything. At least you know that everything is in place. If you need to make any changes, then we can discuss what changes you might want to make. Bless her heart. She comes in and she has a will that was dated 1978. Yeah. And I said, okay, so where's the rest of your documents? She goes, well, that's all. That's all there was. And honestly, back then, that was an estate plan, a will. And the will was about 5 pages long. And she was in her 70s. And and all of the people that she had named as executors in her estate had died. So there wasn't even anybody alive. She had adult children. She had guardians. Let me see. She had guardians named for any children that could be minors. It was crazy. I mean, her children at this point are much older. They're around my age, and it was just it was. I just smiled when I read it because she said, "Well, what do you think?" I said,
it's like a time capsule. Yeah,
it's like a time capsule. I said, but you might want to make some changes. First of all, the people, a lot of the people you've listed in your will are dead. And so we need to review this. And she grinned and she said, yeah, I thought that's what you were going to tell me. So it goes from things like that, where documents are just way out of date, to, people that came to see me not long ago. They had a trust that was drafted. They paid, good money to have this trust drafted. They own numerous properties around the region, many, many properties. And they had a lot of investments, just a lot of assets. And they had this binder. And this binder was probably 3 inches thick. And they sat it down on the table and they said, can you take a look at this and tell me what you think? Tell us what you think. It was a couple. I said, absolutely. I said, before I open it, though, can you tell me what is in the name of your trust? What is what we call funded to the trust? And they looked at me with blank stares. And they said, what do you mean funded? Now, this is a 7-year-old trust. Keep in mind, they think that all of their assets are in this trust. And I said, well, what assets have you transferred to the name of the trust? And they said, well, we thought that when we signed the trust, everything was automatically in the trust. And, that's probably a realistic expectation if nobody tells you that you actually have to quit claim all of your real estate into the name of your trust. You actually have to go to the bank and transfer your investment accounts and your checking accounts and savings accounts into the name of your trust. Their trust was not worth the binder that it was in. It was worth nothing. And I'm telling you, they paid more than I've ever charged for a trust to be done. And so we scrapped it and we had to start over. So, thank God they came in to have me review it, right? Because they would have just continued going on about their way thinking that everything was in the name of their trust until something bad happened, and then they learned the hard way that nope, we're headed to probate court. So we were able to fix that. And then there's things in between where you just have somebody come in and say, yeah, I have a son or a daughter who has developed a drug problem and I need to protect their assets, or I have a grandchild who could stand to inherit and I need to make sure they don't get a hold of their money when they turn 18. So there's a lot of different things that happen in our lives. And estate planning is not one of the top things that would come to mind of something that I need to do. So with our clients, with anybody out there, we urge you to have your estate plan reviewed at least every 3 years. So if you're a client of ours, or even if you're not a client, if you come in and have your estate plan reviewed by us, we will put you on an automated check-in 3 years from now that's sends out a letter that says, or an email that says, hey, we haven't seen you in 3 years. Hope everything's going great, but please schedule a free appointment to come in so that we can go through everything and make sure that everything is still up to date. We have 3 primary sets of documents to review, and they all have different fiduciaries named. They all have different beneficiaries. They all have different reasons that they're in existence. And so 3 years is a long time. Between the ages of 25 and 28, a lot of things can happen. People get married. People start having kids. Between the ages of 40 to 45, that's the primary age that people go through divorces. People in their 50s are what? Their kids are starting to get married. Yep. In your late 50s, you're starting to have grandchildren into your 60s. And then you could end up having a spouse that passes away. You could end up having a child that gets sick, and then suddenly your grandchildren from them step into those child's shoes as far as inheritance rights. And then so a lot of changes happen in our lives, and these documents have to change with you. So the 3 primary sets of documents are not the living will. We just talked about that. They are the last will and testament, a revocable living trust, if you have a revocable living trust in place, and then your ancillary documents. So the last will and testament, everyone needs a last will and testament. And the primary people that are role players in the last will and testament are the executor, and the executor is the fiduciary. That's the person who goes to probate court with your estate to make sure your probate or your estate is probated properly and that your assets get to the people that you intend them to get to. And then the second group of people, if you will, are the beneficiaries. Those are the people who are going to take from the estate. So you have the executor who oversees the estate, pays the bills, makes sure that everything gets to the beneficiaries, and then you have the beneficiaries who are receiving. So, over time, typically when we're younger, we're naming, like, for example, your age, Rob, you've got young kids. You're going to name a sibling, a parent, or a friend as the executor of your estate, right? You're not going to name a 6-year-old as the executor because a 6-year-old can't do it. It has to be somebody over the age of 18. And even somebody who's 19 or 20, they certainly normally are not qualified to serve as executor. You want somebody who's responsible. Keep in mind that your executor here, anyway, well, in every state, is going to take a percentage of the estate as a fee, and that's a statutory fee. So your friend or your sibling who you're naming as the executor of your estate is going to take 5% of your estate. So if you have an estate that's valued at $100,000, they're going to take $5,000. If you have an estate that's valued at $500,000, their fee is $25,000. And that's statutory. So it's just something that they have to elect to take. So as your kids get older, as they get to 20, 21, 22, you might want to name your children or one of your children as the executor, so at least that money that you've worked so hard for goes to one of your beneficiaries instead of your sibling or your friend or your parent, right? Because that's who you want to get your assets to anyway. So, and then beneficiaries. Your beneficiaries, sometimes we name our children. Sometimes I leave my children, Connor Lohman and Carter Lohman, my two oldest children, as my beneficiaries. And then I forget to make any changes. And in my mind, I'm thinking, well, I said I named my children, right, as my beneficiaries. But if I've actually named them and I end up having two more children, they do not take under my estate. So I could state I leave my children, who are then living at the time of my death, my estate. Fine. Or I leave my estate to all of my children per stirpes, which means that if a child has predeceased me, it goes to their share goes to my children. But I'm telling you, a lot of people name their children in their will. And if you name your children in your will and you don't leave that open-ended, then any subsequent children that you have or that you adopt do not take under the will. So that's another reason why we meet. I have got a great couple right now they're pregnant. They're having their first child in January, and they set up a trust, I don't know, about a year ago. They're about 25, 26 years old, and they set up a trust. They're being proactive, and they've already come to see me about who they want to be the guardians of their child that's going to be born in January. And so they're ahead of the ball game. We're able to get the documents in place, and they can go ahead and name a guardian for any of their children, just leaving it open. But it's important to come back every couple of years to make sure that if you have more children or if your financial situation changes, that you know what the effect of that last will and testament are, what the effects of probate court are, because there may be something else that you want to do, like a revocable living trust. So if we want to change the last will and testament, if you want to make a change to the executor or you want to make a change to your beneficiaries, you can do that through codicil. A codicil is like an amendment. Well, it is not like an amendment. It is an amendment to your will, and the codicil simply changes the articles of your will that you intend to change, or you can redo your entire will. So those are your two choices for a last will and testament: a codicil, or you just revoke that will and you redo the will. So those are your choices for last will and testament. For a revocable living trust, you have different fiduciaries. So you are the trustee of your revocable living trust. But if you become disabled or incapacitated, you have alternate trustees who will step in and continue your trust operating during your incapacity or disability. And if you die, then you have alternate trustees who step in to take over your trust. Those may be the same trustees. They may be different. It just depends on you. And if you want different people to handle your trust while you're alive, as opposed to when you die, most people list the same people, but you could have a number of fiduciaries there that were named. And then you have your beneficiaries, the people who stand to inherit. And many people set up, protective trusts for their children or for their grandchildren that protect those assets for them. So coming to meet with us, there's a lot to discuss. You want to make sure, the first thing we do is make sure that all of your assets that you have, anything that you've purchased or acquired or inherited over the last 3 years since we last met is funded to your trust. Make sure everything is in the name of your trust. If you come in and you say, hey, we just bought a vacation home in Florida, great, that's fantastic. Did you remember to put it in the name of your trust? And the answer far too often is, oh no, I forgot to do that. Well, good. It's a good thing you're here, because all we have to do is get that transferred over into the name of your trust and everything's fine. If you've opened new accounts, a new investment account, new money market accounts, anything new life insurance that you've taken out, we want to make sure that everything is directed properly to your revocable living trust. Why? So that if you become incapacitated or disabled, your trustee can continue to operate your trust. And when you die, everything is directed to that trust so that it goes down to your beneficiaries the way you want it to, at the ages that you want it to go to your children, in the manner that you want it to go to them, whether it's outright directly to them or whether it's through a trust. So, things change. When your child is 10 years old, you leave money differently to them than you do when your child is 50 years old. So when your child's 10 years old, you know that there's going to be a guardian for that child. And so you want your trustee, whoever you pick, to be able to work with that guardian, to be able to know exactly what you want your money spent on toward their health, their education, their maintenance, their support. Keeping in mind it's not that guardian's responsibility to financially raise your child. That's your responsibility. So you want life insurance in their trusts. You want everything going directly to their trust that's going to support them. If the child's 18, 19, 20, you have a whole different set of problems. Do you want that child to be able to get a hold of their money, while they're in college and be able to spend it, at will? Or do you want somebody there with them over, looking over their shoulder saying, we don't want to authorize spending for that now. Getting a Ferrari at the age of 18 probably isn't great. How about we go with a Toyota? You may be able to afford the Ferrari, but it may also clean out your trust. So, that's important to look into and to protect. Then when the child's 50, you may say, I'm going to leave it to them outright. Or you may say, you know what, I still want that protection for my child. Yeah, they're 50, but what if they end up getting a divorce? I want to protect those assets from potential ex-spouses, from potential judgments. And I would like for those assets to stay there for my child to draw off of if they ever need it for anything. But if they die and they still have those assets there, I want it to benefit my grandchildren. So, as we enter all these different stages of life, it's important to revisit these documents. Potential trustees die. Potential trustees move out of town. If they were our friends, they move out of town, they retire, they do things. And we need to make sure that we have named the appropriate people and that we keep the appropriate people in place as trustees. And that we keep our beneficiaries updated and that we keep updated how we want our beneficiaries, our spouse, our children, our grandchildren to inherit their money and how we're going to provide safeguards over them. And so that's stuff that we review regularly with our clients. And then the last set of documents that you would amend are those ancillary documents. And we talked about some of those in our last episode. We talked about the healthcare documents, the healthcare power of attorney, the living will, and the HIPAA release form. Those are very important documents that everyone should have in place. The durable financial power of attorney is an incredibly important form, and that changes over time. In Kentucky, we get changes to the durable financial power of attorney all the time by the legislature. They require more things. Banks require more things to be set forth in their power of attorney. Rob, when I started practicing, I swear to you, my power of attorney was 2 pages long. It was 2 pages long. It literally listed items that the person with this power of attorney could do. Our powers of attorney are now about 14 pages long because banks want you to set forth what your attorney in fact is able to do with this document. Closing attorneys, this is huge. Closing attorneys want the power of attorney to state exactly what that attorney in fact can do with that document on behalf of the principal, the person who granted the power of attorney. Let's say your parents or your grandparents are getting older and you're questioning, gosh, how much longer are they going to be able to live on their own? How much longer are they going to have capacity? Well, if you're questioning that, you need a durable power of attorney that allows you to set up a Medicaid asset protection trust on their behalf, that allows you to fund that trust on their behalf. In Kentucky, you can't just set up a Medicaid asset protection trust to protect somebody's assets from Medicaid consideration. You have to have that set forth in the power of attorney. What are the ramifications of that? Well, a lot of kids will come in here, and when I say kids, I'm talking people my age or even older than me, people that are 60, and they say, Mom just fell. She's going in the nursing home. She's lost her capacity to make decisions, and we have to do something, because if we don't move her assets, Medicaid is going to require to spend everything toward her long-term care before Medicaid will kick in a penny. And they're right. First question, does mom have capacity? If the answer is yes, but she's teetering on the verge, then we need mom to sign, this healthcare power of, or this durable financial power of attorney immediately, giving her children the ability to make these decisions on her behalf and to fund trusts. If they say no, my next question is, does she have an updated power of attorney? Oh yeah, here's her power of attorney. Well, if the child's 18, 19, 20, you have a whole different set of problems. Do you want that child to be able to get a hold of their money, while they're in college and be able to spend it, at will? Or do you want somebody there with them over, looking over their shoulder saying, we don't want to authorize spending for that now. Getting a Ferrari at the age of 18 probably isn't great. How about we go with a Toyota? You may be able to afford the Ferrari, but it may also clean out your trust. So, that's important to look into and to protect. Then when the child's 50, you may say, I'm going to leave it to them outright. Or you may say, you know what, I still want that protection for my child. Yeah, they're 50, but what if they end up getting a divorce? I want to protect those assets. It's got the things you need in it. If mom and dad are getting older or grandparents are getting older, that it does allow you to create that Medicaid asset protection trust on their behalf. Those are incredibly important things to have in place. So, coming to us every 3 years, letting us look through these documents, everything may be great, and that's perfect. At least and you're good for another 2 to 3 years. But someday you're going to come in, as you can imagine, and your kids are going to be either old enough to take over as executor, or you're the current person that you've named as executor or trustee, or your durable power of attorney. Those people may have moved, or may have passed away, or may be sick, or may just have had children, and you're like, yeah, this is the last thing I would want to throw on them right now. So, things change, and situations change, beneficiaries change, and you want to make sure that you are up to date and everything is in place, and that your plan is going to work when you need it. I tell clients all the time, you're not going to know if your plan is going to work. That's the truth. You won't know. It's your kids and those people that you leave behind that are going to know whether your plan works. And so having a free checkup every 3 years on your plan, it's the best thing that you can do for those people you leave behind.
Yeah, I love it. and this applies in almost all aspects of our lives, is updating things every couple of years. You mentioned you might have friends in there who you're not friends with anymore and you forgot that they were in there, or, there's just so many things that just doing a simple review can help mitigate. So that way there's not more drama and fighting than there's already going to be when something happens. Right.
And, and part of that review isn't just to review your executor and your beneficiary and all of that, although that is a huge part of it. But it's also to figure out, am I going to waste a lot of money, a lot of time, a lot of my privacy going to probate court? When I did this plan with you, Sean, I was 25 years old, and we reviewed it every couple of years. Well, now I'm 35 years old. I've got $100,000 more of assets that I've worked my butt off for to attain. Do I really want to pay 5% to an executor to put this through probate court? Do I really want to file all of my do I want somebody to file all of my information about my assets and my children and their addresses and my date of birth and the social security numbers and all of that stuff that gets filed when you go to probate court with a will? Do I really want to do that, or am I ready to step up to the next level of estate planning, where I get rid of probate court and I eliminate all of those expenses and I keep things private? So, there's those discussions are had as you start progressing through life and your assets increase, and you go, if you go from children to no children, or I'm sorry, from no children to children, and then children at home to empty nester. So there's a lot of changes that we have in life, and your estate plan has to stay up with it, or it just won't serve those loved ones that you leave behind when they need it.
Yeah, I completely agree. So as always, Sean, if someone wants to get a hold of you, have a chat, do a proper review, LohmanEstatePlanning.com.
LohmanEstatePlanning.com. And if you go there, you can schedule a 15-minute phone call with me. But you can just jump right in. If you're going to have your estate plan reviewed, jump right into a family wealth planning session. Because at a family wealth planning session, we're going to look through the plan that you have in place, and we're going to walk through it with you. We're going to say, how does this play out if something were to happen to you today or in the next few years? Does that work for you? And if so, fantastic. You owe me nothing to do that. It's the best service that we can provide people. If there's a change that you want to make, great. Then we do everything on a flat fee basis. And you know that up front, and you can make a decision. Do I want to move forward? Do I not want to move forward? So at the end of the day, it's all up to you. What we do is we educate. It's why we do this podcast, right? It's why we do our webinar that we offer on our website. It's all about education, educating our clients, letting people know what their options are. And then we turn it over to you, and you make a decision. Do I want to make a change, or do I want to, stay where I am?
Yeah, if people don't have the information, they're not going to be able to make an informed decision, and you've always
100%, 100%, yeah. I mean, to go in and just say, I need a will, these are my kids, and then come back another day and sign it, that's not estate planning. That's doing a will. So,
yeah, absolutely. All right, my friend, well, I think that's going to wrap it up for making some modifications to plans over time. As always, Sean, I appreciate you educating the audience and myself. It's kind of nice to be along for this ride for me too, because it's kind of like getting free legal advice every time I sit down and chat with you on a podcast. So I appreciate it.
Good.
All right, guys. Well, that's going to wrap up this week's episode. If you want to see Sean's website, links, all the details for getting a hold of him can be found in the show notes. We appreciate you guys watching, listening, no matter where you're at. Have a great week, and we will catch you on the next episode. Take care.